rise.
Good morning. You may be seated. We are here on our case number 1CACV170075, ANSLEY et al. Versus Banner Health et al. So, counsel, as you know, there's an appeal and a cross appeal. Each side has 20 minutes to make their cases. You each may reserve any amount of time you'd like to use in rebuttal. If you do, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you, when you approach the microphone, you would give us your name and the name of your clients. We have read the briefs and the record, a good part of the record below, and studied the case law, and also have spent some time discussing the case at conference. So with that, you may proceed.
Good morning. My name is Cameron Artigue. I'm here with Chris Herring and Dick Burnham on behalf of all the appellants. This is one of those cases in which a decision comes down from the United States Supreme Court during the course of the litigation, and the new decision makes all the difference. When this lawsuit was filed, it was very well established that the plaintiffs could go to court, allege that a state statute was inconsistent with federal Medicaid law, and obtain a declaration that it was preempted. In the last 5 years, the United States Supreme Court has issued 2 decisions that bear directly on the viability of that procedure. And in Armstrong, the Supreme Court said there's no cause of action that permits you to do that. And in that case and the Douglas case, the Supreme Court emphasized that the consistency of federal Medicaid law and state Medicaid law is not a matter for generalist judges. It's a matter for administrative expertise, followed by possible judicial review in the United States District Court.
Well, Mr. Artigue, Armstrong is an interesting case because of the nature of the claims there brought by the providers who wanted to be paid more. Their claim was against the state Medicaid agency. And all of these cases, except for this one, is like that. All of them, in all these cases, the providers are suing the state. And all of the references in Armstrong to the limits of the Supremacy Clause and the limits of a right under the Supremacy Clause are couched in terms of when one sues a state actor. So does it even apply here?
Armstrong applies here because Armstrong says there's no cause of action in favor of any plaintiff under the Supremacy Clause.
Well, it doesn't say that, but
it says there is certainly no cause of action under the Supremacy Clause. That's what it says. The fact that there's no state actor as a defendant here, Your Honor, with respect, that cuts against the plaintiffs, not for them. That's the strange, weird aspect of this case, is you've got a sort of collateral review going on of a federal agency decision. If you have a quarrel with a determination that a federal agency has made, you need to sue them. And that's why, and you need to sue them. It could be ex parte Young. It could be the Judicial Review of Administrative Decisions Act. But yeah, the empty chair, the huge empty chair in this courtroom is that of CMS and the Justice Department.
Although the patients say that they've got no beef with the claim, with the state plan. Got no complaint at all with the state plan because the liens, they say, are not in the state plan.
Well, let's talk about that. Let's talk about the state plan. The gist of the plaintiff's complaint is that there's a federal regulation, 447.15, that requires hospitals to accept the Medicaid payment as payment in full. The allegation is that enforcement of a lien is inconsistent with that federal regulation. What does the Arizona State Medicaid plan say about that? CMS says that the payment by access is payment in full except for third-party payments. That's Exhibit 1 to the opening brief. What's a third-party payment? A third-party payment includes a tortfeasor or a liability insurance policy. This is what Judge Gama got wrong. Okay, and he's absolutely wrong in the authority cited under page 33 of the opening brief. Tortfeasors, liability insurers are primary to Medicaid. So that's a third-party payment. Now let's go back to the federal regulation that's the linchpin of the preemption claim, 42 CFR section 447.15. If you look at Appendix 4 to the opening brief, here's the Arizona State Medicaid plan in which CMS certifies that all providers are in compliance with that regulation. So plaintiffs say hospitals are violating. CMS says hospitals are complying.
What exactly is the part of the state plan approved by CMS that the hospitals contend authorizes balanced billing in this case, as opposed to cost avoidance before?
It's. I cut you off, Judge. I'm sorry.
You know where I'm going, as opposed to before the payment is received from access.
I think to say where in the state plan is this authorized is to get off by asking the wrong question. I mean, the state plan is a contract between the federal government and the state government in which CMS reviews, adjudicates, assures consistency between state and federal law. The Arizona statute's presumed valid. CMS said in attachment 4 to the brief, hospitals are in compliance with 447.15. They said in attachment 4.19a, well, the Medicaid reimbursement is payment in full except for third-party payments. And if you look at that in the context of what the agency has said in its prior policy statements, I would direct you to Appendix 8 to the answering brief, where CMS says, in a state Medicaid director letter, providers can pursue payment in excess of Medicaid reimbursement in tort situations.
If they give up their rights.
No, not if they give up their rights.
If they refund the money to access.
That's not what that attachment says, Your Honor. With respect, it says that it does not say that. It says that providers can get reimbursement in excess of, in addition to Medicaid reimbursement. Now,
so what's the mechanism then? If they get reimbursement in excess, are they obligated to refund the money to the federal government?
Yeah, the state does. Yes. What's going on here? When a tort lawyer looks at this, the tort lawyer sees money coming out of the pocket of his client. When a Medicaid administrator looks at this, the Medicaid administrator sees the rational and legal administration of a third-party liability system. Judge Catani, what I would posit is this: if you had a car crash that was settled instantaneously, the tort occurs, the hospital treatment is obtained, and the next day the tortfeasor says, I'm liable, here's my insurance company, the insurance company says, here's a check, it's all settled. What happens? What happens in that situation is access, the Medicaid program, is never billed. By law, it cannot be billed because the tortfeasor is primary. And so access never sees that claim. Now, in the real world, of course, access is billed before the tort lawsuit is worked out. So what all these administrative mechanisms are trying to do is replicate the situation that would have obtained if the tort claim had been settled, instantaneously in the parking lot. And that's why access has a prior senior lien. And that's why the access regulation we cited.
If it's settled, it's presumably settled for the full amount that the hospital would have charged as opposed to the amount that's reimbursed.
Well, what it's settled for depends on a whole host of factors, in how much coverage is available and how clear liability is, and, all the stuff that goes on in the world of tort law.
But under that circumstance, the hospital would bill the full amount, is what you're saying?
The hospital doesn't bill anyone. The hospital has a lien up to the amount of its charges. That's exactly what ARS, the Title 36 statute says. The patient is never billed. The hospital has no recourse against the patient.
The amount of the lien is the full amount, not
Less the access reimbursement. Yes, that is
saying
correct.
there wouldn't be an access reimbursement. I'm saying this has settled in the parking lot after the accident.
Yes.
You're saying the hospital.
In the parking lot settlement scenario, Access would never see the claim. The hospital would have a lien for the full amount of its charges. If Allstate or whomever says we only have so much coverage, hospital, will you take this amount? I mean, you can settle for whatever you want to settle for. But in the parking lot hypothetical, Access would not be out a penny. Access would not need to enforce its lien for a penny.
And the hospital's lien would not be for the access rate, it would be for the
Correct.
whole.
Correct. Absolutely.
And there's another way of looking at the access regs, which patients say is the more proper way. Getting to the issue of whether regardless of what the regs say, are they preempted?
Right. Right.
And how is it? I mean, there are the host of cases uniformly that have held that 447.15 does, in fact, preempt a state law lien. How do you get around the situation that I think the hospitals concede that they could not put a lien on a patient's home for the balance?
There's no lien on the patient. Well,
Right.
the lien only attaches to the tort claim.
Right,
It's
right.
not, okay.
But so you can only put a lien on something if there's a debt owed. And I think the hospitals have to concede, don't you, that there's no debt owed by the patient.
That's the
What's
Andrews
the de-
case, Your
What's
Honor.
the debt? What's the debt that's being enforced by the lien?
The debt is that of the tortfeasor. That's why it is third-party liability. That is why in the world of Medicaid administration, this is third-party liability. The lien is the obligation of the tortfeasor as a matter of federal Medicaid law and as a matter of Arizona lien law in Title 33. There is no debt of the patient. There is no obligation of the patient. There is no recourse against the patient. And that is why state and federal Medicaid law are consistent. If I may, let me just reiterate, if you are curious about this, or if you find the state plan less than convincing, this is not evidentiary. This is law. The state plan is an adjudication of CMS, and the chief body that should explain it, clarify it, defend it, is someone from the Justice Department in Washington.
But what about all the other cases that have held to the contrary? Is there a single case
No.
that's held in your favor?
The cases that the plaintiffs cite, none of them involved a state Medicaid plan that expressly authorized lien enforcement. Absolute distinction right there. Second, none of them were decided under the Douglas and Armstrong regime, in which the United States Supreme Court said, judges of the United States, don't touch this stuff, it's too complicated.
Isn't the complicated nature of it having to do with setting rates and determining amounts of reimbursement that judges certainly are ill-suited to do? But in terms of just making a preemption analysis, why is some federal agency better suited to do that than this court?
Well, it is true that the challenge in Armstrong was a rate-setting challenge. It is equally true that the Supreme Court's identification of that as a matter of administrative expertise had nothing to do with rate setting. The federal government doesn't set Medicaid rates. That's done stateside.
Well, the agency approves it, though.
The federal government approves it,
The
but the
administration
sort of the recipe, all the crunching of numbers and technical details of rate setting is stateside stuff. So it's not even, when you're talking about the necessity for CMS to apply its expertise, you're talking about determining compliance with federal law, which is exactly what a preemption lawsuit is alleging. I mean, this is in CMS's wheelhouse.
Stepping back from Armstrong a second, I guess the problem I'm having is, say one of these plaintiffs, the lawyer for one of these patients, had refused to do whatever was necessary to allow a hospital to enforce the lien, had held on to the money.
Yes.
Hospital sues the patient.
That cannot happen, Your
Hospital
Honor.
sues the lawyer. Well, hospital sues the lawyer. Isn't preemption a defense to that claim? And if not, then why can't the patients assert preemption here?
Well, that's a good point. There is no recourse against the patient. If the lien is ignored, the only recourse under ARS Section 33934 is against the tortfeasor. The patient cannot be. That's the Barfield case and the Blankenbaker case. The patient and the patient's lawyer cannot be defendants. That's why you can't sort of premise declaratory relief on this.
Why does it make a difference then who's suing here? I mean, in terms of Armstrong allowing an injunction.
You can't, just because somebody brings a claim doesn't entitle a state court to adjudicate an issue. You can imagine a state law breach of contract lawsuit between KPHO Television and an employee. And the employee can say in that stateside breach of contract case, you know what, KPHO, your broadcast license from the Federal Communications Commission is invalid. You're not even a legal radio station. Try as it might, the Maricopa County Superior Court cannot adjudicate that issue. It just doesn't have that's a FCC determination. And the state court can't go there. So, and this is the same thing. And it's worse than that, Your Honor. To get back to your hypothetical, you can't second guess agency determinations without letting the agency in the room. I mean, there was recently litigation about the construction of the South Mountain Freeway, the new South Mountain Freeway, over the environmental impact statement. If you're going to challenge that, you sue the EPA, you sue ADOT, because they're the government, and you say, hey, we think the freeway, the environmental impact statement wasn't done right, and this is invalid. You don't go sue Sunt Contracting
Right, okay.
and say, hey, your freeway's illegal, you're enjoined.
I want to give you a chance to talk about Alyeska.
Yes.
What case holds, this is
Yes.
difficult. What case holds that in a preemption claim, in a claim that federal law preempts state law, what case holds that federal law, Alyeska, applies in the determination of attorney's fees rather than state law?
I can't point you to that case. I could point you to page 40 of their brief, which says our claim is a federal claim. And what Alyeska says, of course, is that there is no right to attorney's fees under federal law. And that's the mix and match. You can't say we're bringing a federal law claim and recover attorney's fees based on a state law doctrine.
Is it clear that attorney's fees are a matter of substantive law, not
the attorney's
procedural?
fees? I am fond of the tail and the dog, Your Honor. But yeah, the attorney's fees are the tail, and if it's a state law dog, you determine the tail
part
under
of the
state
dog, is
law
what you're saying.
and so forth. Yes, and that's the mismatch that's going on. I'd like to reserve my time, if I might.
Thank you to the court. I'd like to go ahead and introduce myself. I'm Lance Entrican. I'm here on behalf of the appellees, and I'm here with my co-counsel, Jeffrey Trachtenberg, and also my co-counsel, Justin Henry. Just addressing a few points that were raised very quickly. The first point is that the Arizona Medicaid plan does not and has never authorized this practice. A different panel of this court looked at the portion 419A, page 3, that they cited 4 years ago and said, quote, we have examined, this is at page 485 of the earlier Abbott decision in this case, quote, we have examined the Arizona state plan approved by federal authorities for Arizona to run access. We find nothing in the plan which authorizes hospitals that agree to accept access payments for medical services to place and enforce liens against the access beneficiaries' recoveries from third-party tortfeasors. And note they said the access beneficiaries' recoveries from third-party tortfeasors. At page 486, a panel of this court said, quote, referring to the section that counsel just referred to, That section is merely one sentence in an attachment discussing detailed methods to establish rates for inpatient care and in no way trumps the requirements of 42 U.S.C. 1396A. That section has not changed. It is identical to what it was 4 years ago when another panel of this court explicitly stated that does not authorize the collection of these liens.
So your argument is that Armstrong doesn't bar the claim because your claim arises not under 30A of the Medicaid Act, or in fact it's not even administrable by CMS or Health and Human Services because it's not in the state plan.
Well, that's correct, Your Honor. And just addressing Armstrong for a moment. Well, I'll get to Armstrong in just 1 second. I just wanted to finish this portion, and then I'll talk about Armstrong. The Arizona Medicaid plan at page 29B defines third-party payers as, quote, other health insurance, end quote. And they are citing a letter, June 9th, 1997, a 21-year-old letter from a low-level administrator, and they're saying, and this justifies it, and they're saying why. That letter was addressed by the Sixth Circuit, that precise letter was addressed by the Sixth Circuit in the case of Spectrum Health. The citation on that is 410 F. 3rd 304. And the Sixth Circuit said that letter is entitled to no deference whatsoever because it's from a low-level employee expressing his opinions and does not state agency policy. In Taylor v. Louisiana, 7F Sup 3rd 641, a federal district court decision, they said that letter is entitled to no deference whatsoever. And they said the same thing in Olszewski, the California Supreme Court case, and they made the more salient point that that letter itself expressly forbids what these hospitals are doing. So that is not authorization for anything. There is in the record in this case a level from a much higher administrator, 20 levels up from that guy. He's the general counsel for Health and Human Services. He put in a sworn affidavit, which is in the record in this case, and he said that Arizona has never been authorized to do what they are doing. They didn't seek authorization. They were required to seek authorization under Section 1115 of the Social Security Act, and they did not do so. They've been flying under the radar for decades and not getting authorization, and he stated that, and he's the general counsel of HHS. And the reason they didn't get authorization is because in the early 90s, and this is described in the Olszewski case, in the early 90s, the California Medi-Cal tried to get authorization to do what they're doing, and HHS said no. So they have no authorization from the Arizona Medicaid plan whatsoever to do what they're doing. Going briefly, and they never have had, going briefly to Armstrong. Armstrong dealt with whether there is a right of action under a federal statute. And what is the significance of that? It is whether I can sue for damages to recover under that federal statute because I have a right of action, and whether I can litigate in federal court because my claim arises under a federal statute. The court said our jurisdiction to handle preemption cases is not derived from the preemption clause. It's not derived from the Federal Declaratory Judgment Act. It's not derived from the statute even. It's derived from our equitable powers to strike down statutes as we see fit while at the same time protecting our jurisdiction. They don't want to get flooded with these. And they said we are not going to exercise our equitable powers in this case because Rule 30A under the Administrative Procedure Act very clearly sets up an administrative process to be administered by bureaucrats, not by judges. And the Congress has even stated explicitly they want this handled in the executive branch, not in the judiciary. So because of the particular elements that adhere in Rule 30A or Section 30A, we are not going to exercise our equitable powers. But do you think that's going to stop the court from striking down statutes if they don't like them? The next year, in the Gobel case, Gobel v. Liberty Mutual Insurance, 136, Supreme Court 936, they struck down a statute and exercised their equitable powers because there was no comparable Administrative Procedure Act thing as there was in Armstrong. They are saying, they say explicitly at page 24 of their brief, that Armstrong says a state court cannot adjudicate a preemption issue under the State Declaratory Judgment Act unless the federal statute specifically contains a right of action. Well, since 90% of the federal statutes don't contain a specific private right of action, they are seeing the Arizona State Supreme Court cannot harmonize its state laws with federal laws and hold them preempted, except in the 5 or 10% of cases where the statute contains a private right of action.
If we are under the Armstrong regime,
Yes.
and we need to look at your claim to in the same way that the Armstrong court examined the claim of the providers in that case, under your view of it, do we have to, must the patients show that the plan, the Arizona state plan, did not endorse balanced billing by imposition of liens? Because if it does, as Mr. Artigue says, then the federal government approved that.
No, we do not have to, and that's because Armstrong simply doesn't apply at all. Armstrong is saying you can bring suit in federal court if you can show a private right of action under the statute. That satisfies the requirement that it arises under a federal statute. And also, if you want to sue for damages under a federal statute, you have to show that you have an entitlement to a private right of action. That is totally different than bringing a declaratory judgment action under a state statute providing for that in a state court of general jurisdiction. We're not suing for damages under a federal statute, so we don't need to show a private right of action, and we're not trying to get into federal court, so we don't need to show a private right of action under the federal law. And by the way, just as a footnote, we originally brought this case in the federal district court, and they filed 100 pages saying the federal district court has no jurisdiction to hear preemption cases. But that's another thing. I'm sorry.
Although the providers in Armstrong wanted an injunction, just like, so you're seeking the same relief. We're not talking about damages, I think, in any case, in either of the two cases.
But they wanted to be in federal court, and the court said, and they were arguing, well, we can get into federal court because the supremacy clause and the federal, and the court said, we're not going to open up our jurisdiction like that.
But Armstrong's not a jurisdiction case, I don't think. It's whether a claim arises, whether one can state a claim.
All right. Well, leaving aside the jurisdiction issue for a moment, what the Armstrong court said was, we, a federal court, have equitable powers to pass on whether this is preempted. We choose not to exercise them here because Rule 30A is very unusual. And then they turned around and they tried to exercise them the following year. Justice Scalia, in Section 4, tried to stretch it further and say, oh, no, you can't bring any preemption claim regarding the Medicaid Act in federal court. What he was trying to do was push them all into state court. He wasn't saying you can never bring another preemption lawsuit under Medicaid no matter what anybody does. He was trying to push him into state court. 5 justices shot him down and said no, so they are citing a dissent as the law of the land. And they're saying that dissent says you can't bring these in state court.
Before you go on to your contract claim on the cross appeal, I'd like to hear your answer to the question we posed to Mr. Artigue about any cases that say what to do about Alyeska when a preemption claim is brought in state court.
Absolutely, Your Honor.
I know there are the Arizona cases that you cite that do approve attorney's fees where arguably preemption is at issue, but none of those cases address the issue. So what else have you got? The
only cases they cite, Alyeska and the others, state that they are seeking fees under 29 U.S.C. 1983 or 1988. Every one of them. There's no exception. They are all seeking fees under 29 U.S.C. 1983 or 1988. So, of course, it's governed by federal law because they're seeking fees under a federal statute. We are not seeking fees under 29 U.S.C. 1983 or 1988. We are seeking fees under an Arizona common law doctrine, the private attorney general doctrine. And the courts have been abundantly clear in these 7 citations we've given you that if you seek to hold a state statute preempted under the private attorney general doctrine, fees are under state law. And the best example of that is Defenders of Wildlife versus Hull, 199 Arizona 411.
You know, we've looked at all those cases, and none of them address this issue. They approve, they affirm the award of fees, but they don't take up whether this is the proper analysis. And to the contrary, it seems like the general rule is when you're adjudicating a federal claim in state court, you apply federal law.
The only cases they have cited, you applied federal law on claims brought
Okay.
under 29 U.S.C. 1983 and 1988.
But you don't. Is there a case that's like this where the court takes up the issue?
There is not, in Defenders of Wildlife v. Hull, they said, okay, we're going to find this statute preempted and we are going to award fees under the private attorney general doctrine pursuant to Arizona law.
Okay.
They did not say, and Arizona law controls.
Okay.
But that's the only authority that's out there. And frankly, we began this litigation 7 years ago under the expectation under Defenders of Wildlife v. Hull that since they received private attorney general fees in a preemption claim under federal law, that was the law of Arizona. And unless there's a case that's not decided under 29 U.S.C. 1983 or 1988 that says otherwise, I think it's a reasonable expectation that the court is going to continue to make those awards on that basis.
Well, let's go on to the contract claim.
Yeah, I wanted to, before we move on to the contract, I wanted to hit a key point. They raised an issue, and I think it needs to be addressed. I think it's very important. And that is whether or not this is a third-party collection. In the Blankenbaker case, the Arizona Supreme Court said the lien is not the debt. The lien is a means of collecting the debt. It's a mechanism of collecting debt. The bottom line, the most important inquiry is not who do you have the lien against? The bottom line is who owes the debt? Who owes the debt? In this case, the third-party tortfeasor doesn't owe the hospital a dime because the third-party tortfeasor didn't get any care from the hospital. The insurance company doesn't owe the hospital a dime because the insurance company didn't get any care from the hospital. And that's why in 50,000 cases they have never collected from the third-party tortfeasor or from the hospital prior to settlement or judgment, because the statute itself states the lien has nothing to attach to until there is property in the hands of the plaintiff sufficient to satisfy the debt owed by the plaintiff. And why does the plaintiff owe the debt? Because the plaintiff received medical care. This court at page 486 said, of the earlier Abbott decision, said, nor is enforcing liens for further payments from third-party recoveries obtained by access patients somehow distinguishable from enforcing the liens against the patients themselves. End quotations. This court was echoing Spectrum Health, the Sixth Circuit. It was echoing the California Supreme Court. It was echoing the Wisconsin Supreme Court, all of whom did the same analysis and said the same thing. The debt is owed by the patient because the patient received care. And the hospitals cannot collect from a third-party tortfeasor or from an insurance company until that property has been transferred into the hands of the patient, and they never have. And just as a quick aside, they themselves have admitted that many times in this case. When they were trying to get the claims of the closed lien plaintiffs dismissed, they said in their reply supporting their motion to dismiss, filed August 17th, 2012, quote, both sides performed the settlement agreement, plaintiffs tendered the agreed upon amounts, and the hospitals released their lien upon receiving payment. Payment from who? The plaintiffs.
On the contract claim,
Yeah.
even assuming that the CFR will preempt a state lien statute, and even assuming that the PPAs incorporated either expressly or just because of the premise that law is always incorporated into a contract,
Yes.
the federal reg and the state statutes. In this case, I think the hospitals are saying, but it was never, we never had a meeting of minds on that issue. We always thought we could balance bill. What's the answer to that?
I think the answer to that question was in Nahum, and this is a case that they've just kind of ignored. They haven't really addressed. But on our contract claim, we cited the court to Nahum versus Blue Cross and Blue Shield of Arizona, 180 Arizona 548. That's from 1994. It was this court. And what Nahum involved was it involved an identical provision in a contract between Blue Cross Blue Shield and the hospitals. And the plaintiffs sued, and they said, hey, they can't balance bill us after getting payment from Blue Cross Blue Shield. We're third-party beneficiaries of that contract, and that contract prevents them from doing this. They're in breach. And the hospitals came back, and they made three arguments. The first argument was basically that, oh, we didn't think this stopped us from balance billing. There was no meeting of the minds. And the court's basic treatment of that was this is unambiguous, so tough. And if you look at paragraph 15 of the provider participation agreements, it's not ambiguous. It says payment in full and you can't balance bill. They're very sophisticated. They can afford the best attorneys in the state. They understand that payment in full and no balance billing means payment in full and no balance billing. They understand that. And there is nothing in the record to suggest they didn't understand. There was somehow not a meeting of the minds. Nothing. Nahum's next point was they said, well, the patients aren't stated by name in the contracts. That's exactly what they said here in their brief. And Nahum said in response to that, quote, this is at page 552, quote, although the insureds are not mentioned by name as subscribers, they are clearly third-party beneficiaries of the participation agreement, in quotation.
Does Nahum involve, here we have a state statute that authorizes the balance billing to tortfeasors. And
that's correct.
If both Access and the hospitals have a meeting of the minds where they understand that they can do that's somehow different than the balance billing contemplated just to someone other than a third-party tortfeasor. Mm-hmm. Are you saying that there would be a right for the third-party beneficiary, even though both of them, and they have a statute that backs it up, they breach the contract by doing what the statute says they can do? Or is it just that the contract is void?
You are correct in that there was not a comparable state statute that said, hey, you can't balance bill Blue Cross Blue Shield statements.
But isn't that kind of a big deal in terms of whether there could have been a meeting of the minds, and if both parties, if Access and the hospital say this is our understanding, how do the patients have
Access has not said this is our understanding. On the contrary, the record in this case, and it's the only record of where Access stands on this issue, is the Access website refers to what they are doing as fraud. It's referred to what they're doing as fraud for at least the 7 years of this litigation. Access, we've offered an affidavit from a former general administrator of Access who said we did not know they were doing this, and we wouldn't have authorized it if we did, because it's not authorized. They didn't get the waiver you're required to get from the feds. So Access characterizes this as fraud. And Access, there is an affidavit in the record that says an administrator at Access, one of their top guys, says we didn't know they were doing this. We wouldn't have authorized it if they did. So there was no meeting. There was no meeting of the minds between them that they could do this. They signed a contract saying they wouldn't do it, and then they went and did it. And there is simply no meeting of the minds. There's no record of that in the...
They signed a contract expressly saying we won't balance bill third-party tortfeasors.
Paragraph 15 says that they will not balance bill. And I'd like that, just my time's running out, so I'd like to make that my final point, which is they are not billing third-party tortfeasors. The debt is from the client. They understand that. They admitted it repeatedly in pleadings when it was in their interest to argue the accord and satisfaction. The debt is held by the client. Third-party tortfeasors don't owe them a debt, and they can't collect on that debt until the money is transferred into the hands of the client, and they never have. I'd like to thank the panel.
Thank you.
Judges, just a couple points. First of all, what is their cause of action? I mean, it's remarkable to be in reply in an appellate court, and I couldn't write it down on a piece of paper for you. There are distinctions from Armstrong offered that somehow it only governs a cause of action against the government. I would direct you to the nationwide insurance case cited on page 11 of our reply brief, in which the Nevada Supreme Court holds that there is no Armstrong cause of action as among private parties. I don't know what it is. It's not the Declaratory Judgments Act. It's not Ex parte Young. It's not, and it's a full stop when you don't have a cause of action.
Excuse me.
Oh.
Go right
I'm
ahead.
sorry. Okay, yes. The second point I'd like to make is the unacceptability of the kind of evidentiary flavor that this has taken on. What you hear opposing counsel say is, the administrative material they cite is from a low-level guy at the federal agency, and we have an affidavit from some guy who's 20 times higher. This isn't evidence. The state plan is an administrative adjudication. It has the force of law. It has the effect of law. This court must defer to it. Every court must defer to it. And this is not evidentiary. The stuff about the billing on a lien being fraud, I would direct your attention to the Arizona Administrative Code, R9-22-1007, where you will find an access regulation that contemplates and presupposes that hospitals will enforce liens on the claims of access beneficiaries. What that access regulation says is, hey, hospitals, when you record liens, could you send us a copy so we know about it too? And they don't do that because it's fraud. They do it so that Access can take steps to protect its own senior lien. So you have an Arizona regulation that itself has the force and effect of law that recognizes and contemplates these lien rights. That's why CMS doesn't see a problem here, because federal law recognizes it as third-party liability, state law recognizes it as third-party liability, and you are getting sideways to adjudicate it in a general state court, because the tendency here is to wear the hat of personal injury law, and this ain't the place for that hat.
But we can enforce it if it's a matter of contract law. So if the other courts across the country that have held that the regulation does preempt any state law lien right, was that effectively incorporated into each of the contracts here?
Yes, and I think Judge Gama was absolutely right. At the time these provider agreements were signed, between 1994 and 2002, Arizona statute clearly, unambiguously allowed the liens to be placed. The Arizona Administrative Code, in this provision I just cited, allowed the liens to be enforced.
But if the other courts are right, those laws are invalid under the federal regulation.
No, those aren't. The fact that some court in Kentucky somewhere, said, oh, maybe the Arizona Administrative Code isn't right. This court's decision in La Bombard versus Samaritan Health System, Court of Appeals 1998, said, yeah, Samaritan, you can enforce a lien on an access account.
It didn't address whether the lien was enforceable under the CFR.
It's still a pretty big tea leaf to read
The
if
same
you're
now
contracting. If the time the contract's signed, you say, gosh, the statute says we can do it, the reg says we can do it, the Court of Appeals has given it a green light. Sounds pretty good. I have nothing further. Thank you, judges.
Thank you. Thank you all. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.